In general terms, there are three types of trusts. Very broadly, there are testamentary trusts, there are living trusts, and there are special needs trusts. And there's probably a few others. However, broadly, testamentary trusts are the type of trust that is created inside of a last will and testament. It only goes into effect upon taking the passing of the person. They have to be deceased. The will has to be taken to surrogate's court or probate court in your state. And inside of that will, there's going to be a testamentary provision for a testamentary trust. Living trust, that's the type of trust created when a person is alive. That's the living. And it's in place of a will, typically, and it avoids probate, typically. And then there are special needs trusts. What is estate planning? A plan for who gets what, when. I think that's it. Simple. Over. Period. Done. I do have a note. Who will manage your property, your estate, your assets when you're gone? When you're gone is the polite way to say after you pass away, which is the polite way of saying after you die. So upon your death, what happens to all of the stuff of life, from your personal property to your real property, financial instruments, stocks, bonds, heirlooms, memorabilia, all of the things that you had while you were alive? Who gets that and when? Immediately after my passing, or a year in the future, or at some other point in time? Property belonging to a deceased person is now sitting in a storage locker. And it's about $500 a month. That's an obligation of the estate. The issue here, well, that's an issue in and of itself, but the issue is that none of the family members with priority, meaning a person that might be eligible to receive as a beneficiary or as an heir, none of the people with that priority are looking to file an administration. Situation is a person deceased with no will, no spouse, no children. So the relatives are remote, and we may need to rely on the public administrator to file a proceeding, or to get a relative to step up to the plate. And whenever I do a revocable trust or an irrevocable trust, right, just a trust as part of an estate plan, I always provide a last will and testament. And it's a certain type of will. But why do I do that? Well, I do it, I prepare it, and I have it executed just in case the trust is not properly funded. However, if the trust is properly funded, if we take the necessary steps, the correct steps, to retitle assets, you will never need to use the will. So the will is a document important and potentially necessary, and it protects the client, but it should not be used if you do the right job with the trust. You should know that if you have a trust and you want to give as part of your distribution plan to children A, B, and C, right? You may or may not name your children A, B, and C, but there are people out there that do. So say A, B, and C in equal shares. What happens if A is incapacitated at the time A is supposed to receive their specific bequest, their portion of the distribution? What happens if B has predeceased the parent and maybe C is alive and well? Well, we can plan in advance what's going to happen in the event that B, in our example, predeceased. Well, is it to the heirs of B or the children of B or the other A and C in equal shares? A prospective client came in today about selling a piece of property that was in trust. And as we were discussing this, it was shared with me that this person's parent has both a property in New York City and a property in Florida. And that is one of the several reasons why a trust would be a perfect vehicle for this person to own both properties. If in fact, so her mother had has a will, and in the will there's a certain division of assets. However, because the properties are owned in two different states, that will would have to be probated first in New York, and then once you receive the letters testamentary, they would have to be taken to the state of Florida, where an ancillary probate proceeding would take place. And we're talking about delay. A client consult for a last will and testament, that involves several important things. So when you meet with the client, this is after a person has asked you questions and wants you to be their attorney. So have to explain the process from beginning to end. Have to explain the importance of a will, why a will is necessary, and what the functions of a will is. Function of a will is. Then get the testamentary scheme, the plan from the person. What assets do they have, and where do they want the assets to go? Who are the natural heirs of this person, spouse, children, and then how. I was asked a question at a webinar, what can you do if your family member is on drugs or has a drug addiction? And the context of it was, you want to give money to this person that has an addiction. How do you protect this person as your beneficiary? Well, the best way to do that is, instead of giving money, bequeathing money, right? Providing for this child in your will directly to my child, John Smith, $1 million. The better, more appropriate option in that case, and you can use it in other instances as well, is to open up within your trust or your estate plan, provide it to that child inside of a trust. For my child, John Smith, a trust in the benefit of John Smith. Am I making it more confusing or less confusing? If I was going to leave money to a person with an addiction or a past addiction, and we didn't want to give that person $1 million, because with a lot of money, a small addiction becomes a large addiction, perhaps. So what we would do is, I would give it to the trust of John Smith and give a little bit of money, and have a trustee have some discretion on how much money to give, or make it in tune with milestones. If John Smith graduates college, if John Smith gets a graduate degree, if John Smith is able to wants to buy a house or needs money to buy a house, just set up certain parameters. And it can be done, and it's a very effective way to keep the money out of John Smith's hand, but only for his benefit, and also to keep it away from the heirs, not the heirs, a bad spouse, a creditor, some other kind of predator out there. All right, if you need more, if I can further explain, reach out. You should know that the largest segment of the world at large that's fighting in court are families. Families fighting. For some reason, my office has an emphasis on family fighting, whether that be in the divorce world, right? Husbands and wives, mothers and fathers fighting over children and money, property and custody. And in the guardianship world, siblings fighting, step-parent against adult child. Who else do we have? nieces and nephews fighting over older relatives. So in the guardianship world, and in the surrogates court, families, siblings, cousins fighting over an estate. I have a client that's in the middle of a divorce and wants to do a will. In the will, she would like to disinherit her husband and leave all of her assets to her two children. The mutual two children, right? With the husband that she's in the middle of getting a divorce with. New York State does not allow you to disinherit a spouse. Not actually. So in the will, we can place a term that says I am something like this, right? From my head. I'm specifically disinheriting my spouse. I'm in the middle of a divorce. Little line there. Now, it's up to the husband, in the event that she passed away before the divorce is over. She'd be married. The divorce would be abated by death. And he could, in theory, in actuality, actually, let me say it that way, he could exercise a right of election. And that means he can inherit as if there was no will. So in that instance, if the divorce was not finalized and my client passed away, the husband would receive, and if he exercised his right of election, he would receive the first $50,000 and 50% of whatever remains. Now, if they were married, it may in fact be that a lot of their assets are joint, or the property, or a bank account. There might be many joint assets, and therefore he would get all of those assets by operation of law automatically. But any individually owned asset from that separate pool of perhaps separate property, if he exercised the right of election, he would in fact be entitled to it. What should we do? Well, let's try it and see what happens. Maybe, hopefully, probably, she will live for many decades after the divorce. And the will prepared now will be moot. Had a client come in today for a trust signing and a will signing. Why both? And how do you conduct a will ceremony? So when we do a trust, my approach is that I also prepare a will. A last will and testament, the terms that we use is a pour-over will. P-O-U-R. Not a poor person, a pour-over will. Fictionally, think of the idea of having a pitcher and pouring the liquid that's in the pitcher. And the reason for that is when you make a trust, you need to properly fund the trust. Take assets that you have in your individual name and place them into the trust. But if you fail to do that, or do it incorrectly, and you have an individual asset, the pour-over will push it into the trust. This way we make sure that we scoop up and gather all of the assets. Now, the idea isn't to leave the assets outside of the trust and then upon death utilize the last will and testament to pour all of the assets over. That's a fail-safe. That's if mistakes were made or after obtained assets never made their way into the trust. But in order to have the full effectiveness of the trust, you need to fund the trust while the trust maker is alive. If you have a trust, but there is no money in the trust, you will not have anything. What do I mean by that? Well, if you have a trust that is unfunded and the person passes away, well, there's nothing in that trust to distribute. So the trust could say everything to my two children, one child, everything to charity. The charity or the children cannot get it because there's nothing in it. And that means if the person died, their assets would pass by some other method. Maybe there's a will. Maybe there's no will. Maybe there are beneficiary designations, right? I don't know the specifics of this fake situation. However, the trust would not be effective without funding it, and there'd be some other something going on. You should know, the court wants you to settle. The court does not want people to go to trial. I don't know why. Well, maybe I do know why. The court thinks it's best if the litigants, the persons on each side of an issue, bend a little, yield a little, give a little, with neither party being fully satisfied. The court thinks that's better than an either or. So if you have a situation where you're fighting for money, one person wants, I'm going to make up numbers, 100,000, and the other person offers 20, the court may have to decide and may have to choose between the two. Whereas if the parties meet in the middle, 65,000, 72,000, 58,000, some other number, the court is more satisfied than if they had to pick a number. And by the same token, if people are fighting for custody, and I want the child. No, I want the child, right? How do we parent together? Well, there's only 7 days in a week. So even if I win custody, and my office, myself, my associate, we routinely are in custody litigation, right? Routinely. So we're not against doing that. But we do promote settlement because there's 7 days in a week. Even if I win custody, I'm getting 5 and the other parent might get 2. It might be 4 and 3. How do we split the week? How do we co-parent? If we can arrive at a mutually agreed upon settlement while not being completely satisfied, it may make sense rather than leaving the decision up to a judge. That's what we try. How do you know when to settle? Facts and law and circumstances and specific fact-based decisions, right? One person works nights, the other person works days, one person has off during the week, middle of the week. All of those things factor into place. Proximity to school, proximity to after-school providers or nannies or who could watch, and so many things go into it. And we take an assessment of that in advance. We do a pros and cons. We do a checklist. We discuss all of the possibilities, from a little bit and a small and a loss all the way to a win. And where are we on that, on the gradient scale?